Hello and welcome to Newsmaker. I'm Parikshit Luthra. The Parliamentary Standing Committee on Finance has approved its report on the Competition Amendment Bill 2022. The new bill is expected to be tabled before the Parliament in a few days. The new bill proposes to regulate mergers and acquisitions based on the value of transactions, among others. Also deals with transaction value of more than 2,000 crore will require CCI's approval. So what were the issues before the Parliamentary Committee? I'm now joined by Jayant Sinha, the Chairman of the Parliamentary Standing Committee on Finance and BJP MP as well. Mr. Sinha, let me begin by asking you about some of the issues before the committee. The report has now been adopted. It will now be tabled before Parliament, and then the government can make some changes to the competition bill. Now, there were questions over the deal value threshold of 2,000 crores. There were issues before the committee which said that there should be periodic revision of the deal value threshold, and clarity was needed on how the deal value is actually arrived at. What has been the committee's recommendation on that front?
Good evening, Parikshit, and very nice to be with you. The Competition Amendment Bill, which was introduced in Parliament during the monsoon session, came to the Standing Committee. And over the last 3 or 4 months, we have been examining it very closely. We have consulted with many stakeholders and heard a wide range of opinions on the amendments that have been moved. I will emphasize that this is the first substantial set of amendments to the competition law since 2007. So this is happening after 15 years. And the amendments that the government has moved and on which we have provided our comments through our report are very substantial amendments. They are making some very much needed and important changes to the competition law as it exists right now. You have highlighted, Parikshit, one of the most important ones, and that is the deal value threshold calculation that will be used to see whether a particular merger or a combination should be examined by the Competition Commission of India or not. So previously, as you probably know, if you crossed a certain threshold, for example, in terms of assets or in terms of turnover, then the merger was within the purview of the Competition Commission of India. In this set of amendments, the government introduced an additional criteria, and that was the criteria of deal value threshold, which has been set at 2,000 crores. So, for example, if you're a digital company or a tech company that's buying another company that may not have high assets or high revenues, but it is a very valuable acquisition because you are acquiring some very important technology or a very important customer base. And if that limit exceeds 2,000 crores, then it will fall within the scope of the Competition Commission of India. This is what the government had suggested as part of its amendments. And we have examined that provision very carefully. We have suggested a few refinements to that to just make it work even better. And to enable companies to have even more clarity on exactly how this will be applied.
Right. Could you give us a sense of some of the recommendations on that front, sir, in order to make it more transparent for the industry, make sure that there is no legal issue later on?
So the exact details, Parikshit, will have to await our recommendation being tabled in Parliament. So I can't really speak to the exact recommendations. But our goal was to be able to take government's intent and to make it even more transparent, even more predictable, and even more precise, so that companies would have a very predictable and a very clear set of rules that they could follow.
Right. Also, one point was about the definition of control. And this is something that some companies had also raised, about a clearer definition of material influence. What do you feel about the definition of control as per the amended law?
No, that's a very important point, Parikshit, that you're bringing up. There were 2 or 3 very important aspects of these amendments. One was, of course, the deal value threshold. The other was about this question of control. The third is about settlements and commitments. And then there's a fourth one in terms of exactly how the investigations will proceed. So these were some of the major areas that were touched upon through these amendments. And you've picked on another very important one, which is control. Now, when you acquire control of a company, you have to be very clear as to what is defined as control. And there are really 2 broad standards globally. One standard is what is called decisive influence, and in decisive influence, you acquire, let's say, 51% of the company, you have decisive control on the company through board seats, through voting rights, and you can really set the business model and the policies that the company is going to follow. That standard is called the decisive influence standard. There's a second standard, which is a weaker standard, and that's called material influence. So you can have control of a company once you start to exercise material control, and material control can be defined in many different ways. So for example, if you have board seat on a company, then maybe you have material control. If you acquire 26% of a company, then you might have material control as well. So that material influence standard is in fact the standard that has largely been practiced in India. And again, I can't give you the exact recommendations till the report gets tabled in Parliament, but our goal was to be able to get even more specific on exactly what is meant by control. So again, companies that are facing this kind of scrutiny from the Competition Commission of India would know exactly what standard is being applied and how it's being applied, and how it pertains to their particular combination or their particular merger. So our goal here in this very important provision of the amendments as well was to really make it clear what kind of influence we're talking about, decisive influence or material influence, and then to be able to sharpen those definitions so that companies would know very clearly which side of that line they would fall.
Right. Now, as far as the admission of guilt for commitment and settlement, we believe that the provision in the bill on commitment and settlement has been welcomed by the industry and also members of the parliamentary panel. But do you think the admission of guilt should be mandated in the law? And do you think the bill is clear enough on this aspect, Mr. Sinha?
So there is a global practice when it comes to these kinds of negotiated agreements on commitment and settlement, which is that you have to give flexibility to the regulator, to the Competition Commission, as well as in a way to the parties that are subject to this kind of proceeding to be able to negotiate what they think is the right outcome. So you have to provide that flexibility. That's largely the global standard right now, and that's essentially how this bill is also set up, the amendments that have been brought in for settlement and commitment. Let me add that bringing in settlement and commitment in this bill is an extraordinarily important step forward for our competition law. It immediately brings us up to world-leading standards, and it provides a way for us to be able to settle matters without going into a long, drawn-out set of proceedings, through first the Competition Commission of India, then NCLAT, which is the appellate body, and then from there to the Supreme Court. So typically, without this ability to achieve a negotiated agreement, we were in a situation where an outcome could take years and years and years, which obviously would not be good for India's economy. Now, with the ability to either get a commitment or a settlement, depending on where you are in the proceedings, we have an opportunity to close the chapter on these kinds of proceedings and really establish clarity and predictability for our businesses. So this is a very, very important landmark reform in competition law that the government has introduced. And of course, as I said, this requires flexibility in terms of how the negotiated agreement comes out, whether there is guilt or there isn't guilt. There's one other very important aspect to the commitment and settlement process that I want to highlight, and I want all viewers to understand, is that once you come up with this negotiated agreement, there is no appeal by any party that's possible after that. So you bring all the parties together, you work out what the negotiated settlement agreement should be, and once that's done, that closes this chapter, that ends the proceedings, and then there is no appeal to the NCLAT and the Supreme Court thereafter. So all parties have to agree to this being kind of the final decision. And that brings, again, as I said, very, very important sense of closure to some of these proceedings, and allows businesses and companies to get on with their work, and allows the Competition Commission to move on to other matters as well. So the ability to be able to have a negotiated agreement and then not have it being appealed, I think is extraordinarily important. It's a really vital reform that has been undertaken as a result of this.
My final question, Mr. Sinha, how do you think this bill will make it easier for companies to do business in India?
So there are three very important aspects to this from ease of doing business perspective. Number one, what the government has sought to do, and then we have tried to really enable this even further, is to create very, very high predictability and very clear understanding of exactly how the rules will apply. So, predictability and transparency is very important. That really is necessary for ease of doing business. So that's one very important objective. The second very important objective is this ability to do a commitment or a settlement and get to a negotiated agreement so that, as I said, you can close the chapter and move on. And then number three, there are various provisions like the deal value threshold and so on that enable us to bring within the purview of the Competition Commission of India certain matters that can impact competition in India but could not be brought in a lawful way and now will be possible to be brought in. We've also strengthened the investigative powers and so on of the Competition Commission of India, and that I think also will enable those people that are looking for justice to be able to get that justice efficiently and quickly. So when you look at all of these different measures that have been undertaken, I think businesses, companies in India should feel very reassured and very encouraged that we have a world-leading competition law on our books.
All right. Thank you very much, Mr. Sinha, for joining us on the show, telling us about the CCI Act, why it's important for Indian businesses, and some of the changes that you have recommended to the government. We're going to take a short break here on Newsmaker. Up next, an exclusive interview with AstraZeneca's global chairman.